നോക്കി നോക്കി യൂട്യൂബ് സ്റ്റക്ക് വരുന്നുണ്ടല്ലോ. പോയല്ലോ. വന്നാ ലൈവ് വന്നാ? ഓക്കെ തുടങ്ങിക്കോ.
Good evening, everyone. A warm welcome to all the participants joining us today. Thank you for taking the time to be part of this free webinar on Digital Personal Data Protection Act 2023 Board and Leadership Briefing. This session aims to benefit students, working professionals, and leaders by offering a clear understanding of data protection laws and their growing relevance in today's digital world. My name is Akhila, and I'm delighted to be your host for today's webinar on behalf of Avanzo Cyber Institute. Before we proceed, only those who have registered through our registration link will be eligible to receive the participation certificate. So I'll be sharing the link in the chat box. Kindly ensure you complete the registration. Today, we are honored to welcome our guest speaker, Advocate Pattathil Pranav Menon. It is my privilege to introduce a distinguished professional who works at the intersection of law and cybersecurity. He is an accomplished advocate with strong experience in legal advisory and cybersecurity governance. He has guided organizations in understanding technology, compliance, and digital safety. As a data protection officer, he helps organizations protect sensitive data, follow data protection laws, and build trust with their clients. With his combined knowledge of law and cybersecurity, he continues to contribute to strengthening data privacy and promoting responsible digital practices. We are privileged to have you with us today, sir. Thank you very much for joining us. Before we begin, kindly keep your microphones muted and you may post your questions in the chat box. We will have a dedicated question and answer session at the end, and cameras are optional. So now, without further delay, it gives me a great pleasure to invite Advocate Pattathil Pranav Menon to lead today's session.
Thank you, Akila, for the introduction with those kind words. So, before we begin, why such a session at such a time, for especially for leaders and for the board members of industries and businesses? The TPDPA rules just came out a few weeks back. So every business has about 18 months till May 2027 to be compliant with those rules. So I think it's the right time to be talking about this topic, and it is the right time to be having such conversations. So first of all, I'll start by I'll begin my briefing by thanking Avanzo Academy and Avanzo Cyber Institute and the whole of Avanzo team for giving me the opportunity and for talking the relevant stuff, making those relevant conversations. So without further ado, I'll begin my brief. So this is mainly webinar that is tailored for board members of a organization or the leaderships of the decision making. Hi, before I move on, am I audible right now? Or so if you can just give me a thumbs up or put in the chat box. Okay, sure. So if anything, just give me a second. How about now? So I mean, I'll start once, and once if you guys, if everybody. Hi. So I'll start and I'll move on. And if there is any issue with the technical stuff, you can just. Okay. Thank you, Miss Seema. Yeah. So if there is any disturbance or if there is any problem with the audio, video, the technicalities of the slides, you can just put it on the chat box. And if you have any questions, that too. So we'll go on. We'll start with the first slide. So the context behind DPDP Act, that is Digital Personal Data Protection Act. Let me begin by setting the governance and constitutional aspect of this topic. Uh, DPDP Act exists first and foremost because privacy in India is no longer a policy preference, but a constitutionally protected fundamental right. This was unequivocally been recognized by the Supreme Court and the Parliament, especially by the Supreme Court in various judgments. Uh, Primarily the famous Puttaswamy judgment. And then now it has been formally recognized by the Parliament and the legislature, so the act is formalized. Privacy is a fundamental right under Article 21, right to life and liberty. So, right to privacy or right to private affairs is now more than just a formality, because now you have a special legislation that governs privacy in the digital realm. Secondly, India's economy right now is such that there is a lot of technological transfer, between borders of different countries. There's a lot of cloud infrastructure, global data flows, and the earlier framework that governed us is basically was the IT Act of 2000, and it is pretty absent about uh, protection or protection of privacy rights. So right now, DPDP Act is a little more nuanced, very well formulated. Some people would argue that it's not strong enough, but hey, something is better than nothing. So the third reason for why DPDP exists is because globally there has been a rise of legislations, from the GDPR, Global Data Protection Rights regulations, which was formalized by the European Union. Later, the UK adapted its own GDPR, and now Singapore and Brazil also have recognized data protection rights. Now you see that almost with India's most of India's trade is also with the Middle Eastern countries. So now Saudi Arabia has always also created their own version of personal data protection legislation. Then UAE also has a similar version. So in a growing global context, in a geopolitical context, and we always say whoever is in this field of cybersecurity and data, we say data is the new oil. So each country is trying to protect its own sovereignty of the data of their own their citizens. So DPDP or such a legislation was always warranted of existence. It should have been it should come into existence because it is also a form of protecting the sovereign rights of the citizens of a nation. So these are the primary reasons why such a legislation has come forth, and DPDP Act therefore represents India's transition from a technology-centric statute, I would argue, from the IT Act to a rights-based, accountability-driven governance framework. Why do I say it is a governance framework? Because it is mostly related to compliance measures and what you should and what you should not do. So, and from a corporate governance perspective, because most of the people who are going to get affected or who are supposed to create a framework are corporates. So, this is more of a legislation that focuses on corporate governance also. Um, so, moving on to the scope and applicability of this act as to what data is this applicable to, whose data, and where it applies. The scope of DPDP Act is intentionally very broad in the sense that it applies to digital personal data. And what is personal data? Any personally identifiable data, that any piece of data that you can identify a person with. That's the loose definition of it. So any such data that is in the digital form. And what do you mean by in the digital form? So either you have collected the data in a digital form, or you have collected it in a physical form, and then later subsequently you have digitalized such data. So a photocopy of someone's Aadhaar, if it's in the digital format, a photograph of someone's Aadhaar, an Excel sheet containing names, addresses, and Aadhaar card numbers, or such data. Health. If you are a hospital, the hospital IDs or Abha IDs of individuals in an Excel sheet or a Word or a in your database somewhere, that one piece of data, if it is
Screenshot play.
identifiable or can be connected towards an identity of some person, then that is what usually in the industry we call as digital personal data. And interestingly, this act applies extraterritorially also. So, doesn't matter if you're a company that is registered abroad, if you are in possession of data of Indian citizens, or if you cater to Indian citizens in the geography of India, then or else, or if we have data of Indian citizens in your hand, then this act would apply to you. And the exemptions for these regulations or governance frameworks are very narrow, very contextual, and specified in the act. And mainly those are statutory, largely tied to state functions, law enforcement, or specific notified purposes, which is there in the act detail and in the rules also. The other exemption that not really an exemption, but the idea behind this is that corporates only need to collect data that is absolutely essential and essential for their product offering. So, if you're a home delivery business, you may not need the PAN card details of that person, but you will essentially need their address and phone number. So just collect those that is essential for your service offering, and leave the rest. And if you're collecting them, tell the people why you're collecting them, for what purpose you're collecting them, and don't use it for anything else. So that is the basic context of uh, the applicability of what data. So if any organization touches personal data linked to an identifiable individual in India, the act almost certainly applies. So, and if you are processing it, and when I mean processing, it means if you're using the data in any form to do any kind of an activity, then most certainly this act applies to you. So coming to the main conversation, why is this something the board members of a company has to be aware of or diligent about? This is basically an act or a legislation that is meant for the board's perusal. Uh, if you see the corporate structure of any company in Indian corporate law, the principles of Indian corporate law, the directors owe fiduciary duty of care, diligence, and oversight, because the directors are the ones who are ultimately responsible for the management of the company. The directors and then comes the second layer of management. So
Ah,
even if a prosecution is being taken against a company, it is almost most certainly the directors who are liable for the conduct of the company in general. So regulators no longer ask whether a breach was accidental. They ask whether the board exercised reasonable governance or not, especially in this legislation. Uh, and globally, the structure has been say of such that the board has to make measures that would project care for the data of their customers or their citizens that they have, or personal data that they have in possession. So the second element of why this is a board level risk is that the enforcement philosophy is that whether the board has understood the risk of what happens in case of a breach, whether it has asked the right questions, and whether it had already taken steps or systems to stop it to a reasonable extent, and whether there was an oversight in those systems that was placed. And while the penalties of such a the fines come in crores and crores of rupees, it also exposes the leadership towards the citizens or their customers that they don't care enough. So it is a trust-based legislation. If I am to draw parallels, it would also be you can draw a parallel to consumer protection. So how seriously does a consumer brand take consumer protection? That is the same way the legislature intends you to take this legislation also, because once you are found of you know guilty, or you found of having made an offense or an oversight according to DPDP Act, the initial thought that comes inside the general public who has entrusted you with their personal data is that you don't care about the customers enough. So it's a trust question that comes. So this is a board level risk, not because of the financial aspect of the fines or the penalties that is in place, or the enforcement philosophy behind it, or whom this is meant to be addressed. It's also about the trust that the consumers have on a corporation. So one small step would one small step of not enforcing DPDPA organization wide, or not having a quite good framework according to the law, would result in an erosion of enterprise trust. It will impact investor confidence and valuations. It would create credibility issues of the leadership of the organization. Fines are one thing, and then, yeah, basically, it's a huge risk for the board. Now, under the DPDP Act, liability is anchored to one central concept, that is the data fiduciary. Now, before we go into that, we should understand the regulator's mindset is that data is not an IT asset, it is a governance asset. And governance failures are failures of immense value. And coming to the liability act, is under the DPDP Act, liability is mainly attached towards the data fiduciary. Now, the organization that determines the purpose and means of processing personal data is the data fiduciary, and this responsibility cannot be outsourced. Now, with the definitions of what a data fiduciary is, what is data processing, everything is, we'll come to we'll discuss this in detail in the subsequent slides. And I would request all of those who are listening, if you have any doubts, just either post it on the chat box so we can come in and we can address those in the end of the Q&A session, or you can just note it down somewhere and then you can ask me when I'm ready to take questions. So the basic understanding is that there is somebody who's collecting data for the purpose of using such data for certain some purposes, if using it in a certain way. And whoever collects data for using that data in a certain way, in a certain manner, for a certain purpose, that person or that entity which collects data from a person, from a citizen, from a consumer, from a customer, that person is data fiduciary, who almost most certainly defines what kind of data they should collect, how that data should be processed, in what manner, in what way, who should process it, and for what purpose. So the person who makes such a definition is the data fiduciary, and that is where the most liability is fixed. So he is responsible for the implementation of what do you call as the DPDP framework or the data privacy framework. And you can't outsource that liability, or you can't outsource that responsibility to someone else. What you have to do, you have to do. Uh, while you may have vendors, cloud providers, and consultants who act as data processors, again, we'll come into the definitions of these in subsequent trials. Uh, subsequent slides, sorry. Uh, the delegation of such activity will not dilute the accountability for the entity that collects data. And you can't transfer liability through way of contract also. So, from an enforcement standpoint, regulators look for what the data fiduciary has done. So, the primary mode of collection of data, whoever that is, they see if they have done documented decision making, audit trials, have they done risk assessments, and have they created demonstrable compliance records, etc. Uh, so largely for this act, for the data fiduciary, intentions do not matter. So you might have outsourced it with the intention that they would have the best care, but it doesn't. If you have documented proof, documented audit trials, documented risk assessments, that matters, and only that does. So intention is not considered anywhere in this act. So the primary liability of this act lies with the data fiduciary. Now, coming to the key definitions of what is what. So these are the major terms that you have to understand when you're reading the DPDP Act. So data principal is the individual whose data is being collected. So it is me, you, your friend, your mother, your sister, your father, your brother, your husband, your wife, your boyfriend, your girlfriend, your professors who sign up on an application or sign up on a website, or who go onto a website and accept cookies, whose data is being collected. So I'm the principal. So when I get into an app, let's say, if I'm being asked for your details, if you're being asked for the details, you are the principal. It is your data that is being collected. So that is what you have to understand. Data principal is your individual. So from a corporate standpoint, data principals are your customers or target customers, or your potential customers from whom you're collecting data. And data fiduciary is someone, like we discussed in the earlier, is somebody who defines for what purpose that data is being collected. So, and that differs from industry to industry, and it differs from service sectors to service sectors. Those definitions. And now data processors. These are somebody who takes on the role of processing from the fiduciary. So to give you an illustration is would be such that if I am a entity, I'm a home delivery partner, or a home delivery application that provides you with delivery of food from the restaurants. I collect your data as your phone numbers. I decide what kind of data I need. So, and I tell you that, hey, I need your phone number, I need your address, I need your name, I need your banking information, because we UPI information, because there's online payment. I need your credit card because if you are wanting to credit card details, because if you're wanting to give me credit, pay through the credit card, I need your credit card details, and I need your you know date of birth, because if you want offers for uh, date of birth for your birthday month, for your birthday, I certainly need to know your date of birth, and tell me about your family. So because your wife's birthday, whatever. So I'm the person who's collecting those data. So I'm the data fiduciary right now, and I decide what I should do with these data. So I would say, anybody who's having from, let's say, birthdays in January, I would say to my marketing team, send them a marketing email, tell them that you have 50% off because it's your birthday month. So that is processing of data. So you've used that data for some need. So you're sending marketing emails. You're using it so that you can use your algorithm better. Uh, and if I'm collecting data of you surfing through your browsers, searching for the best restaurants, blah blah blah, and if I'm to send you suggestions about what you're looking for, your preferences of what you're looking for, and that is the processing aspect of it. So I take all your information and then I use analytics or some kind of technology to give you something, or send you something, or do something with it. That's mainly the basic idea of processing. And I decide for what purpose the data I have collected should be used. So that is why I'm a data fiduciary. I collect and I decide for what purpose it should be used. And data processor is somebody who, so sometimes in majority of the cases, the fiduciary is the one who is also processing the data. Sometimes I would give out such processing to a digital marketing firm or a data analytics firm, or some third party who has the expertise in the process, the kind of processing that I need. So the person who have outsourced this processing, they become the data processor. So the data processors use the kind of data they have from an instructions they have received from the fiduciary. So that's the loose understanding of it. And significant data fiduciary is somebody who has high volume of data, who has collected a high volume of data, and they have higher regulatory expectations and standards. So your Facebooks, your Instagrams, your Googles, your Gmails, your Twitters, they are significant data fiduciary because they have a big, huge chunk volume of personal data that is available. Uh, these definitions are not semantic. They have very clear purposes. They determine who answers, who explains, and who pays. In the sense that who is accountable, who is liable, and who is responsible for some actions, or who's responsible for the other. Now, coming to enterprise responsibilities, the Act imposes affirmative obligations on enterprise, including lawful and clearly defined processes, purposes, and there should be strict data minimization. Collect only what is necessary. So, like I said, I gave you the example of a home delivery application. Why do I need your PAN card? I don't. The data fiduciary does not need your PAN card because all I need to do or provide you the best of the services is your address, is your phone number to get in touch with you, and your name. That's it. Wow. Maybe I need your email, but I do not, certainly do not need your Instagram browsing history or your Google Chrome browsing history, what you've suggested, what you've looked for. I certainly do not need your health details or health insurance details. So that is the second principle, that collect only what is necessary. And the first one is lawful and clearly defined purposes. So when the data fiduciary is collecting data, They should have a clear idea why they are collecting this data for, and they should clearly communicate it to the data principal.
മുസ്ലിങ്ങൾക്ക് അങ്ങനെ പ്രശ്നമുണ്ട്.
And DPDP Act
എത്ര വയസ്സ്?
also
23, 22 വയസ്സില് അത് വലിയ പ്രശ്നേ.
you know
എനിക്ക് എത്ര വയസ്സ്?
pushes the board to have
IRC
structured retention and deletion governance. So once you've collected the data, you can't keep it forever. You have to delete it over some period of time, and you should retain the data in such manner that it's safe. And you should have certain safeguards when you are retaining such data. And if you're deleting the data, you should tell the customer. If you're retaining it, you should tell the customer. So transparency is a big. It's given big importance in the whole of legislation. So uh, you should communicate what you're the purpose of what you're doing it, so it should be clear defined purpose. You should tell them why you're collecting the data for, and strict data minimization, like we discussed earlier, and retention and deletion governance. And then you should implement reasonable security safeguards and internal records that demonstrate compliance. So they want to make so the legislation forces the board to not make this compliance a one-time thing. So they want to create organizational discipline in the in as a culture, so that it is a continuous task of what we do, how we do, and how we tell it to the other people. So
Screenshot
this is basically flowing from the same principle of data as the new oil, because we see such constraints in the financial audits and financial controls given by the MCA to the corporates. So this is another
the
safeguard so that the data is not misused, because the misuse of data will lead to larger loss than a financial misuse of financial control. So
അത്
coming to the
അങ്ങനെ
most
type
important part is
ഇതിനു വേണ്ടിയിരിക്കാൻ
the next slide is consent. Now this is where what we have discussed so far comes in, and which gives you clarity about it. So why should you be so transparent with your customer? Why should you tell them what you're doing with their data? Why should you tell them what data you're collecting,
അല്ല
how you store it, what security safeguards you have created in your company, when you will delete it,
അങ്ങനെയല്ല ഞാൻ
what
ഇവിടെ
internal
കറക്റ്റ്
records do
പറഞ്ഞില്ലേ
you keep?
അപ്പൊ ഇതിന്റെ
Why should you communicate your organizational discipline, if you have any, to the consumer? That is because this legislation empowers the data principle to have, or gives primary importance to the data principle's consent. And the consent must be free, specific, informed, and unambiguous. Uh, you can't like create accept cookies such or do you accept privacy and terms and conditions, and you could just click. If you don't click, you can't use it, use the application. You can't do such gimmicks anymore. You should be able to, and you can't just for privacy and terms and conditions read the paragraphs and paragraphs worth of additional tab that is going to happen. No, you can't do that anymore, because the legislation is drafted in such a way that the consent has to be obtained in such a way that after going through the privacy policy of your organization, the person who is to give you your give you their personal data should know without any bias that what you are going to use it for. And you will see in the rules and on the DPDP Act and in the general conversation with the uh, government and circles of data protection that they're giving encouragement to people who are going to gamify privacy policy and not use that very boring legal standard format also. So why such a move is to this is to ensure that if a person is given their personal data to someone, that they have given it out of their sheer free will and nothing less. And the one more important thing about DPDP Act is, or any privacy legislation for that matter, is consent must also be as easy to withdraw as it is to give. So if so, I've gotten a question here. I'll take it up without. I'll take the questions at last. Uh, so so the basic thing is, if it is easy for you to give your consent, but to take it back, if it's very hard, it's not going to happen the same way. Yeah, there's an old saying in Malayalam that if there is a bridge, it has to be of the same length for both sides, or for both travel. So from point A to point B, if there's a bridge, the distance from point A to point B should be the same as from point B to point A. So it's the same principle. So you can't say, we'll take your data, you just need to say yes. And you can't say that, hey, we'll stop whatever we're doing with your data, but you need to go through this, and make it hard for them to say no to the consent. It shouldn't be like that. So that is another thing. It should be withdrawable as as easy as it was to give you the it as easy as it was for them to give you their data. And most critically, proof of consent is also mandatory. So if tomorrow something happens and they say, "Did you obtain consent?" You should have a record of them, a record of that data principal giving you the consent to process their data willingly of free will. And you can search in Google, because most predominant proof is the privacy policy. We will come to it, but if you can search on the go through a perusal, because of the privacy policy not being interactive or not being proper enough, where consent could have been misread, or it was not specific or informed. The European Union has fined, or European countries have fined, even Netflix for those matters, huge companies, millions of euros. And it's going to be the same in India also. At least everybody in the data protection circle hopes it to be. So the thing is, consent is what primarily matters. So because that is why the effort has been given in the legislation to make the corporate board, or the corporate entity, or the data fiduciary, to be more transparent about what you're going to do with the data. And we will go to the rights of the individuals right now. Uh, what are the rights that the data principals have? And these are very mainly related to right to access their data. So whatever whatever data that they've given you, you should have a record of what each principal's data that they've given. So let's say you have 100 clients, and each of the 100 clients have given you different data. They should have the access of their own access of records that you have kept of their personal data. And individuals have the right to correct their data. They have the right to say right to forget. I'm sure most of you would be getting calls from Bajaj Finance or other finance people asking if you need a personal loan, and you would most definitely be able to use this. You can just tell them, "Hey, I have a right to forget. Please don't call me again." It's that easy when the legislation is implemented, which is till May 2020, which you have time till May 2027, and you have the right to have grievance redress. So these are the broad major rights, and one right that is very exclusive towards the Indian data protection regime is the right to nominate. So once you are incapacitated to make decisions about your personal data, what happens to that personal data is a big question outside the Indian regime or outside the Indian jurisdiction. But for the Indian regime, for the Indian jurisdiction, this legislation has come up with a clever way. You can nominate a person who can take decisions on behalf of you with respect to your personal data. So if today I am incapacitated to tell Bajaj Finance to not call me again, or don't use my data to process whatever it is, I can just nominate when I'm giving my data on the privacy policy that, hey, if in the event of my incapacity to decide on my personal data, such and such person, it can be a mother, it can be a son, it can be a wife, your husband, your father, your brother, doesn't matter. So that nominated person will then have the right to uh, take decisions on behalf of you with regards to your personal data. And this is another way that the act ensures that there is transparency between the data fiduciary and the data principal, because first thing is that you have to take consent on a clear basis, that consent should be free, it should be, there shouldn't be any pressure that, hey, if you don't give us the consent, you won't be able to use this data, you won't be able to access other things, blah blah blah. It shouldn't be forced in any manner, it should be absolutely free. And once you have given the consent and you've given the data, what are you going to do with it is another thing. And now this is where these rights create that level of transparency that is uh, required in this field. Mr. Subin, I understand. So I will be taking questions at the end of the day. So if you can just drop the questions on the chat box, it would be easier because at the end of the presentation, I can come to it. Um, so now coming to significant data fiduciaries, what are the added duties? Uh, this is not just limited to significant data fiduciaries. You have to appoint a data protection officer. Uh, this is the appointment of data protection officer is not just limited to SDFs or significant data fiduciaries. Once you have enough data, enough critical data, or enough personally identifiable data, you are supposed to hire a data protection officer, uh, which is everybody has personal data with everybody. So when the definition of what is a significant data fiduciary is immaterial for your appointment of a data protection auditor officer, I would suggest from the day that they've said to implement uh, the DPDP Act, if you're small, you're big, doesn't matter. It's like having a CA for your financials. Hire a data protection officer either as an employee or on a freelance basis, because that it prevents you from falling into trouble. I mean, that's what I suggest. And then for significant data fiduciaries, they're supposed to have independent audits and they're supposed to have impact assessments. And so they have an enhanced obligation because the number of data, the volume of data they have is different, and then sensitivity of data. Like if you are having a biometrics of some person, if you hold health records of some person, and also the kind of people's data that you have will also make a slight difference in whether you become or not become a data protection officer, or whether you become a significant data fiduciary or not. So just going off the conversation for a bit, when I'm talking about data protection officer, the post of DPO comes at the management level. So generally, you see in the corporate world that you have the board of directors, and then below them you have the CEOs, CFOs, and CTOs, CISOs, etc. DPO comes between the board of directors and the management. So he's more of a single point of contact for the board to uh, you know check whether the data production regime that they have formulated or the discipline that they have formulated is implemented in the right way or not.
There is a disturbance.
Yeah, Mr. Padmanabhan, if you can just mute for a moment.
Participants, kindly mute your microphone, please.
Thank you, sir. Sorry for the inconvenience, everyone. I'm sorry for the disturbance. Now, discussing as why privacy policy is important as a governance evidence. Like I said, there's only one document that proves that you've obtained the data with full consent, and one document that absolutely proves that the way you have collected data is in the most proper way, and that is privacy policy. And that is where your data protection governance starts. You have a faulty data privacy policy through which you collect your data from the data principle. Like I said, from Netflix to Google to Amazon, everybody's having problem with it. If your privacy policy is wrong, or in the way it is not up to the standards of what the law prescribes or what the regime prescribes, there starts your problem with data privacy. Like I said, it has to be clear, the accuracy of what you're trying to do. So if you are a home delivery business, your privacy policy should say, hey, we need this data so that we can process these data in such manners so that we can efficiently provide you with these services. And for essential data, for in all practical way, for the data principle, they know that if they don't give their addresses, they won't be able to efficiently serve you. So uh, so they won't be able to efficiently use those products. So for that mandatory required, you have to tell them these are mandatory for us to provide that service for you, and then they can either accept it or not. But then you can even ask for additional information. It's not like you can't ask for their PAN details or your credit card information or UPI or whatever it is. I'm just giving an example out there. You can, but they have the option to not give you that. And when they do that, you should not tell them, hey, if you don't give this, we can't provide the service for you. And this privacy policy is also a record. So when something happens and somebody gives you a complaint with the data protection board that they have used my you know my private data for something which I've not agreed to. The privacy policy is essentially a contract that you enter with the individuals from whom you're collecting the data. So that contract has to be very accurate. It should align with the actual practice. It should be it should be clear. It should be transparent, and it should be gamified for some. That is that it shouldn't be endless in a way that you see right now, where you go into the data privacy terms and policies and you see endless papers nobody reads, and if you don't accept, you can't go into the app or the application or the website. It shouldn't be like that. So that is what the primary thing is, and this is the first evidence that comes to your rescue when you go get into trouble with data breaches. Again, I'll be taking the questions at the end of the day, end of the presentation. Um, so, what is data breach? Uh, what counts as a data breach? And what should you do at when the data breach happens? Data breach is when your database has been attacked from cyber attack. So it can be your, you know, again, I'll come to the questions. So don't get wary that I'm not answering your questions. I'll come to the questions at the end of the slides. So what constitutes as a data breach? If you can't access the Data Principles Act data that you have stored. So any ransomware attack, any breach of your website, your any cyber attack that you have faced, and that stops you from accessing the data that you've collected by winning the trust of the consumer, is a data breach. Doesn't matter whether somebody has taken the data or copied or deleted it, or once you lose the access to define what you should do with the data, that's a data breach, essentially. And if the customer cannot access the data that they've given you because they have the right to access, that is also a data breach. So once such a breach happens, what is your obligation to do? Right, you are mandatorily asked to report to the data protection board and the affected individual. So let's say data of, if you are an airline and data of passengers that have been flying with you for the past 5 days have been breached or have been affected, you should first inform the data protection board saying that, hey, such and such data have been affected from this date to this date. We found out now this is what has happened and this is the records, this is what we're doing. You should do that to the data protection board. And you should tell the affected passengers also, say, hey, your flight with us from this date to this date. Unfortunately, the data from this date to this date have been affected and your data is also included. And the more you delay that such kind of a reporting mechanism, or it leads you to trouble. And if you have the disclosure that you have made is incomplete, you don't tell what, you say, 80% data is gone, while you say 20% data is gone, while 80% is at risk, you'll still fall in trouble. So transparency is the key everywhere. From taking the consent to when the breach happens, transparency is the key. The legislation wants you to be transparent with the governance body and with the affected individuals or the data principals. Now, coming to what is the data protection board, it is an enforcement board. This is similar to your company law board, which was which was present during the before the NCLT regime. It is also, you can compare it with your TRAI, you can compare it with your RBI, you can compare it with your IRDAI, etc., etc. So this is a regulatory body with the power of civil courts. They have the power to inquire, direct, and penalize. So it is also a SEBI kind of a board, Security Exchange Board of India. So it's a parallel to that, with whatever is, with all that is related to data. DPB has their jurisdiction over that. They have the power of a civil court regime, so they can order the police station to investigate on certain matters. They have the power to create an inquiry. They have the power to direct you to come summon you and then make a representation, and they can conduct a summary procedure if they want to. So DPB is such a body that is ingrained to enforce the DPDP to its teeth. So it's a body with teeth. That's what I would say. And the biggest risk for any board is the penalty structure. You have penalties ranging from 5 crores to 250 crores per violation. And India has slightly been on the lower side of giving penalties, monetary penalties, when you look at other regimes, especially if you compare it with environmental law scenarios. India is very bad at giving fines, but this is that one regulation which starts fining people in crores and not in lakhs, and that is a big change. And whoever you are, small entity, big entity, bigger entity, the biggest entity, doesn't matter. You will, if you are found of violation, you will be paying in crores. 250 crores is not a small amount for any organization. That's it. And data fiduciary is also responsible for vendors, like I said. So you can create outsource processing, but if they don't create adequate measures, as a data fiduciary, you'll still be liable. So everybody will get fined. That I'm just adding on to this point. So what do you do to address this compliance framework? You should create data mapping as to what kind of data you have collected from whom all. You have to classify the risk of your the data that you've collected. Let's say someone's bank credit card details are at the highest risk. Their health data is also at the highest level, while their name can be on the lower level. You can create consent architecture, which is unified for all in a way. Like I said, a uniform privacy policy, which is very detailed. You can also create board level reporting metrics, mechanisms, periodic impact assessments, etc., etc. And then one thing you can also do is to I'm sorry, I just lost my train of thought. So you can also implement methods with respect to data anonymization or data pseudonymization, so that you take away the identifiable, the word used in the legislation, out of it. So once you do that, and then even if the data breaches, then you are somewhat safe to say that, hey, we had metrics too, so all data we have is anonymized or pseudonymized. uh, as to what these processes are, I would suggest you consult a DPO for your organization, because it's very technical and is very it's a time intensive process and a technology intensive process. So with that, I think I'll just wrap up and move on to the question answer session. So final takeaways for a board is that DPDP is a legislation that enforces trust, or which wants to create that trust factor between your customer and the enterprise. DPDP Act is not a compliance law; it is a trust legislation. Like I said, you can compare it with your Consumer Protection Act. And in the digital economy, trust is the basis of customer loyalty. It is the foundation of investor confidence, and it is also the currency of sustainable growth. Boards that treat data protection as governance will lead. Boards that treat it as paperwork will eventually answer for it in some way or the other. And the cost is very high, because people right now take privacy as, like I said, the country has recognized this as a fundamental right, but people take it more seriously. So once you lose that trust, it's hard to gain it back from a very business point of view. And that's the key takeaway. Whatever you're doing, it's to earn trust. All the compliance and governance that is mentioned in the DPDP Act or the legislation is to, you know, foster an environment where you can build the trust to the customer, so that the customer is also loyal, saying, okay, yeah, my data is safe with these people, because they openly communicate with me whenever this happens, that happens. If something bad happens, they tell me. If something good happens, they tell me. They tell me what they're using this for, etc., etc. And it's also a way of frequently communicating with your customer base, again, saying that, hey, we value you so much that we don't want to misuse your data. We don't want to use your data without your permission, etc., etc. So this is also a great way of creating that customer loyalty and creating that trust within the customer to come back to you as an enterprise. So this is the final leadership takeaway that I want to give to the directors who are all the business people right there. Now I'll start by answering the questions. So one of the questions is, what are the legal and financial risks for leadership if non-compliance occurs? So yeah, legal risk is basically heavy fines from the Data Protection Board. And financial risk is, I would say, while the fines are direct financial risk, the indirect financial risk could be the loss of customers, because once you are found of a non-compliance, the trust erodes from your customers who've given you their data, and they would just, if you're not loyal with them, why should they be? It's a very simple question, and slowly you'll start realizing the financial risk for it. And so the next question. I hope it answers your question, Miss Dia. And the second question is, if consent is bundled inside long terms and conditions, will it still be considered valid under DPDP? The answer is no. According to the current text, according to the current understanding, I can't speak about it because it's still not enforced right now with 100% clarity. But according to the current understanding, it is, if consent is bundled inside long terms and conditions, it is not considered valid. The consent, like I said, the privacy policy is the instrument through which you collect consent, and it has to be clear. It has to be, it has to be separate. It has to be gamified, and it has to be accurate, transparent. It should be basically saying you can't fool somebody to get their consent. So that's the basic understanding. So you can't bundle it into something else and then say, yeah, we got the consent because he said yes to the terms and conditions. It's not like that. I see a raised hand from Mr. Subin Sugaran. So if you can just ask the question.
Hi, Mr. Pranav. It was very informative session. Thank you very much. Actually, I have a couple of questions. Like I actually one or two questions I mentioned in the chat box. So I will ask directly. So
Sure.
see, you mentioned the customer can retrieve the evidence what he submitted, right? So like he right to call back or right to take back his evidence, right? Like Aadhaar card or something.
Not evidence, the data. So it's basically the customer has the right to tell you that, hey, forget me. So delete all my
Okay, it's like
data.
a DND, like the do not disturb.
Yeah, but more formalized. The difference between DND and the right to forget or right to erasure is that in DND you still keep the data. You're just not acting upon it.
Okay, so
Right to
we need to
forget,
erase. Okay, for the
yeah,
calling purpose only. But
it's
see,
never
I see. Yeah, actually, when I read this one, I have a doubt on this because we are a financial sector. So someone want to cancel his Aadhaar card or evidence what he submitted, so we cannot continue the investment, right?
yeah. So right to forget means that I no longer need your service. Please delete my data.
Okay, so right to audit also you mentioned. So see, what are the levels they have? See, okay, customer have a doubt on what he submitted his personal data. So how so they have a right to audit, correct?
Uh, right to access. They can ask you what all data I have given you, and then they can.
So see, what are the level we need to show to them? Like, okay, since we are a financial sector,
Yeah.
so they want to access. Okay, they want to see. Okay, what are the see? We use their Aadhaar card or we use some other things. So we need to show them. Okay, tell them we are using only for this purpose, or do we need to show our database?
Not your entire database, just the customer's data. And all I'm saying is this in the current understanding of the text, because right now it is not being practiced, right? It's not being implemented. So when it comes to practice, there may be changes, but the
Mhm.
current text says that if I am your customer and I say, hey, I need to see what all data I have given you permission to take, you are required to give me a data or a sheet saying that, hey, Pranav Menon has given me your Aadhaar card, PAN card, this.
Okay. So thanks, Pranav. See, my final question is: see, this DPO position,
Yeah.
you mentioned this is in middle of CISO and the board, right? But in Europe or see, I was been in UAE also. So
Yeah.
DPO was directly reporting to CISO, not directly reporting to directors in Europe and UAE. So that's why I have a doubt on this one. So DPDP is anywhere it's mentioning DPO is directly reporting to directors.
I think there's been a change in practice right now because DPDP has made this understanding that DPOs are to report to the board directly.
So they
Uh,
anywhere mentioning like any qualification, certain qualification or certain experience they required for this DPO position.
you need to be a certified DPO. I am certified by Data Security Council of India. There are other certifications also. I'm also a PECB certified DPO for EU GDPR. So there are a lot of certifications that they mandate. But like I said, the DPB, the Data Protection Board, is not yet enforced. So it's not been formed. So when we will have more clarity onto the qualification that is required for a DPO position when the board is formed, because the ultimately the DPO is to report to the director board and the data protection board.
So currently they are not defining what it is mandatory to have a such a qualification, right?
Yeah, it is mandatory.
Yeah,
Mandatory.
yeah. See, I understand it should be, but it's not evident. It's not recordically they need this much qualification or this much
No,
experience, right?
no. Right now it's in the gray area because they say you need to have
Okay.
valid experience, blah blah blah. But still, that is not because the practice of this is not started.
Thanks, Pranav. I'm not taking your time because a lot of questions will come. So thank you very much.
Sure. So the next question is DPDP is similar to GDPR, I guess. Any comparison data, for example, if a company is GDPR compliant, will it cover most or full of DPDP requirements? There are small, jurisdictional differences, but yeah, for the most part of it, it is the same. So if you are GDPR compliant, then for about 80 to 85% you are DPDP compliant also. But it's like saying, yeah, I'm compliant to UK's or European Union's Consumer Protection Act, but for India also you need to have different standards. So there are small differences when it comes to DPDP and GDPR, and yeah, but it's almost the same. You're right, sir, Mr. Sajid Raj. Uh, Next question is, what about data shared from our bank and other government departments? So I think these come under the exceptions because largely all processing done by the government is out of the purview of legal processes of your data is legally it comes out of the purview of the legislation. This mainly is for the illegal or the processing of data that is being uh, done by the corporate entities. So yeah. And the next thing is, can an outdated privacy policy itself be treated as evidence of negligence and misrepresentation? Yes, and it has been. Well, we don't have cases yet in India that has come out, but in GDPR jurisdiction there have been, and a lot of companies have been fined in millions of euros and dollars if you just want to search. So yeah, an outdated privacy policy is treated as evidence of negligence and misrepresentation, and you will be fined. At least people were fined, and I hope they will be fined in India. So the next question is, if violations are caused by vendors, does penalty liability still rest with the primary organization? The vendors also will be fined. So will be the primary organization, because they're supposed to tell the vendors you need to have certain safeguards, and they should be doing certain audits with the vendors that, hey, are you actually doing those? Yeah, so both will have penalty liabilities. If records are incomplete but no harm is proven, how does the board assess liability? Uh, if so, I think that uh, I will tweak your question. If the records are incomplete, there is harm. I would say it in such a way. Uh, so the board can assess the liability in such a way that if the records are incomplete, then the act prescribes penalties. So that is your liability. If that has answered your question, Mr. Anil, uh, I hope I have answered your question. If you have any doubts, please feel free. I think we have time. Do we have time, Miss Akila? Hello. I hope people are not asleep.
Hello.
Do-
We will wait for 10 more minutes.
Okay, sure. So please send in your questions if you have any. I hope, in the meantime, I hope everyone enjoyed the session, and I hope it was not long, boring, and you know, very dry. I hope it was very interesting for everybody who was inside. Please let me know your feedbacks. It will help me give non-boring sessions again in the future and correct myself. And please send in your questions, please.
Okay, we have shared the feedback link in the chat box. So please share your feedback and let us know.
Thank you, Mr. Anil. Thank you so much. I hope you will hire me as your DPO as well. On that on that note, because the webinar was good. So uh, please do fill in the feedback form, and uh, huge shout out to oh, the link is not working. Anyway, huge shout out to Avanzo Cyber Institute, Avanzo Academy, and the team Avanzo for smoothly organizing everything. Special thanks to Miss Akila for introducing me very in much fine words. Uh, she did make me look good. So thank you, Miss Akila, and please send in your feedbacks, and please on
We
follow.
will check the feedback link and send it again in the chat box, okay?
Okay, thank you, Killer. Please keep following Avanzo Academy, Avanzo Cyber Institute, and the Avanzo family, because
Chat box ಇದೆ
uh,
like
we are trying to have the conversation, rather, they are trying to have the conversation that is absolutely essential for this day and age. Uh, every day we see, uh, you know, crime happening in the cyber world, and cybersecurity being much more relevant, and data being at the center of it. Both data security and cyber security is uh, very relevant topics in today's world. So
nothing is working.
huge shout out to Team Avanzo. Thank you for inviting me. Thank you for bearing with me. Fill in the feedback form. Go follow the socials of Avanzo. They have great LinkedIn account. They have great Instagram. Uh, and join back for every webinar. And I hope session was too good for today. Thank you all. Thank you so much.
Okay, thank you, Pranav. Thank you, Pranav, for this wonderful session. And we would like to express our sincere gratitude on behalf of our entire team at Avanzo Cyber Institute. And a heartfelt thankful for to all the participants for your active presence and engagement. And as a gentle reminder, please ensure that you fill out the registration form to receive the participation certificate. And we have shared the feedback link in the chat box. So fill out the feedback form and share your feedback. I hope there are no more questions. So we will wrap up this session. Thank you, everyone. Wishing you all a wonderful evening ahead. Thank you.
Thank you.
Thank you.